Welcome back after the break. You're watching Markets at Noon, and let's shift focus to a story which has impact not only in the legal fraternity but the banking sector as a whole. State Bank of India has decided to classify the loan account of beleaguered telecom firm Reliance Communications as fraud and also report the name of its erstwhile director Anil Ambani to Reserve Bank of India. Remember, RCom has been under insolvency since June 2019, and the legal counsel of Anil Ambani has also objected the move. Let's understand one by one what has happened so far. So, State Bank of India has sent a letter on 23rd of June saying it has identified or tagged RCom as fraud account, and it is not limited to the company but also naming Anil Ambani. What will happen now? The letter will be sent to Reserve Bank of India saying that this account is now a fraud, including Anil Ambani, and the next steps will be taken by Reserve Bank of India. What is the company saying on this matter? Now, Reliance Communications has clearly said that fraud will have no impact or as far as the CIRP proceedings are concerned, because when a company is under insolvency and RCom has been undergoing insolvency since 2019, there will be no impact citing section of 32A of IBC, and therefore even Reliance Infra, another listed company of the firm, has also said that since it is a different listed company, it will not have any bearing. Even a letter has been sent by Anil Ambani to SBI claiming, counsel is claiming that SBI passed a fraud order ex-parte, which means a hearing which was not given to Anil Ambani before tagging account as fraud. Remember, he is citing Supreme Court judgment whereby it is mandatory to give an opportunity to the party before being tagged as fraud. But there are more details on this matter, and it's not just RCom but other flagship companies under Anil Ambani's Reliance are also not in good shape. What's the update on that? I have with me Sharad.
In focus are the ADAG group stocks, and one by one we will give the status update for them. The first one is Reliance Communications. Now, SBI has classified RCom's loan account, which is roughly 40,000 odd crore rupees, as fraudulent as well. Now, this is coming in regarding the fund diversion dating as back as 2016. Up next is Reliance Capital. It had undergone insolvency in November 2021 and later restructured via IndusInd International's 9,650 crore rupees resolution plan in early 2025. Looking at for Reliance Home Finance, it has defaulted and SEBI and RBI actions are ongoing. But for Reliance Power, of course, there is a restructuring happening and a turnaround in the offering. Reported a net profit of 126 crore as compared to loss, and also it has reduced its debt equity ratio to 0.9 times. Last year it was 1.6 times. Interestingly, Reliance Naval, now it's of course under Swan Energy, it is showing a defense interest is coming very big on this. And lastly, Reliance Infra, they have pushed their standalone net debt to nearly zero and are raising roughly 17,000 crore rupees in fresh capital. NCLT ordered bankruptcy proceedings related to 88 crore default linked to 2011, and also NCLAT has stayed the order, and the next hearing would be on 18th July this year. Also, defense JVs coming up with Dassault and DHL, Germany, and other players are also something which the street will be looking out for.
All right, thank you so much, Sharad, for all those details. But then let's take more insight on this. We have with us Shriram Subramanian, founder and MD in Govern. Hi, afternoon, sir, and welcome to the show. Well, very important to understand right now what's going on and the legal grounds for this fraud classification. If you could just elaborate on, how SBI defined fraud in the context of corporate loans and what are the consequences of such classifications?
Yeah, good afternoon. Thank you for having me on the show. SBI has taken the RBI's new framework of July 2024 into account when classifying or referring these Reliance Communication account to RBI as a fraud, and also Mr. Anil Ambani as a fraud, because the detailed statement which has been put out by Reliance Communications itself has a SBI letter and the reasons thereof. As of today, over 28,000 crores was outstanding, and because SBI has said that there was diversion of funds, and the funds were utilized for purposes for which the loans were not sanctioned. So to that extent, the two promoter entities and the end use of the funds were not as envisaged. So from that purpose, SBI has classified the Reliance Communications as well as the promoter, Mr. Anil Ambani and its entities, as fraud, and is referred to RBI under the new framework of July 2024.
All right, Mr. Shriram, Ankur this side, I want to know from you, since this fraud account is now referred to Reserve Bank of India, you mentioned about 2024 norms. As per those norms, what are the steps which Reserve Bank can take now?
One is, of course, the moment Reserve Bank recognizes it, there is a central fraud repository. So this will, the Anil Ambani Group promoter entities will go into that fraud repository or registry. Two is, I think the larger implication will be that for other group companies, banks and financial institutions in India will not be able to lend money till there is a resolution or till there is withdrawal of this fraud tag. So from the if the moment RBI recognizes it and pushes it into the central registry, the ADAG group entities will likely not be able to get any make any borrowings from Indian banks and financial institutions.
Mr. Subramanian, these firms are already under insolvency since 2019. Right. So I want to understand from you, is there any legal complication now per se? Can Reserve Bank of India refer this case to investigative agencies? How do you see this scenario? Are these options now open?
This is actually a consequence of the forensic audit itself, which was being instituted by the Committee of Creditors. One. Two is there is no practical reason for another forensic audit or anything to be done by or instituted by RBI, because Reliance Communications itself is under insolvency. But I think Reliance Power and Reliance Infrastructure, which are on a revival path, so to say, I think those two large companies would likely be impacted by this fraud registry or fraud tag if it is done by RBI.
One thing that, we really would want to understand, what is the basis of Anil Ambani's legal counsel, objection on SBI's decision, especially calling it an ex-parte order? What are the scenarios where this ex-parte case can be considered? If you could just elaborate on this.
No, the RBI framework of July 2024 itself provides for a hearing to be given to the person or a legal entity which should be termed as fraud, was the forensic audit. I'm sure SBI has taken into consideration those situations. May not be under this new framework, but probably some older framework. So that legal implication, or that's, I think, a nuance which we'll have to see how it will pan out, because this regulation itself is new. The number of cases are new. Just because SBI has given ex-parte or not provided a proper hearing probably to Reliance Communications doesn't mean that they need not be termed as fraud.
Subramanian, this case has been going on for very long and NCLT has not approved the resolution of RCom yet. I want to understand now that this account is tagged as fraud, will it have any impact on the insolvency proceedings? Will there be further delay? And more than that, one pertinent question is there: why did SBI and Canara Bank took so long for tagging it as fraud?
Yeah.
To answer your first question, I don't think there is any practical implication to NCLT. There is already a huge backlog for NCLT, and there is no recoverable assets or anything of that sort. NCLT is known for delaying matters, and there is huge deterioration of assets by the time they take decisions. Two is answering your second question. I think at the end of the day, the fraud tag may not delay matters, but SBI may have just taken this fraud tag because the new framework just came out in July 2024, and after that, SBI may have deliberated and arrived at this conclusion.
All right, so we should be open for further regulatory or legal steps looking at the current juncture that we are. Is that open?
I would doubt it is open, but obviously the Anil Ambani group will try to avoid the fraud tag by challenging this one by SBI, and I mean, because it has implication for other group companies which seem to be on the revival path, which is Reliance Power and Reliance Infrastructure, which seem to be on the revival path, having raised equity funds and getting customer traction.
From a banking industry point of view, what we know is that most of these loans are already been tagged, they are already provisioned per se by the banks. So on balance sheet per se, I don't think so there will be any impact, because whatever amount is supposed to come has not come yet. That is the only delay which banking industry should watch from this particular happening of SBI tagging this account as fraud now.
Yes, see, obviously provisioning doesn't mean if there is anything recoverable. Obviously, banks would like to recover if there's a quick resolution. If NCLT order is passed and there's quick resolution, even liquidation, whatever can be recovered, at least that can be returned back to the books. Yes, it's been provisioned, the 28,000 crores, but that doesn't mean that this fraud tag will have implications for the banking sector from a perspective of its exposure to Reliance Power and Reliance Infrastructure.
One last question, Mr. Subramanian, before I let you go. This matter has been hanging for a while, especially I am talking about RCom. COC has already approved the resolution plan around 2 years back, but NCLT is yet to give final approval. Do you think there is a possibility of resolution here, or you think the company going into liquidation?
No, this is a sad state of affairs. It's a systemic issue because even though COC decides, NCLT takes its own time, and that time frame should be, and that is defeating the IBC process itself. I think the government has to look into the IBC process itself to ensure that these large accounts especially are resolved quickly, so that the banking industry gets back whatever is due. Otherwise, asset deterioration is the key.
All right, so that's a clear picture of what's going on and what could happen in future as well. Thank you so much for joining us today and helping us and our viewers understand this entire matter. Thank you.